I am going to talk about a topic that may not seem very interesting, but surprisingly has come up quite a bit in the recent days. This is about the Foreign Investment in Real Property Act, the FIRPTA. And this is an act that refers to a seller who is not an American citizen or has permanent residence goes to sell a piece of property, and what happens when he is selling that property. There are certain basic things that we will need from a seller. Now, first of all, we will need to know whether he is a foreigner or not. And if he is a foreigner, a form that we provide through our opening of escrow, it's called the Foreign Investment in Real Property Act form, it's the FIRPTA form, cannot be filled out. Contrary to what some people think, when a person comes to purchase a property and he is a foreigner, there's not anything different that we need from him that we wouldn't want from another buyer. He just has to come, deposit the money, close escrow, and he's got the property. The problem comes when he sells the property. As a seller, he will need to fill out a form called the FIRPTA form. And this form states that he is not a non-resident, meaning that he does have the right to live legally in the United States. If he cannot sign this form because he does not have a green card or does not have legal residency, then he will need to have funds withheld. The FIRPTA is a buyer's responsibility. Even though it is the escrow officer who handles all the paperwork, it's important to remember that it is the buyer's responsibility to have all of the funds that have to be withheld sent to the IRS. Obviously, the buyers don't know what to do, so they usually ask the escrow officer to do it, and that's why the escrow officer has to be very much aware of all the rules and regulations. One of the first things that is required, and this is very important, is that this foreign seller, in order for him to sell this property, he will need to have a tax identification number. That's the TIN number. Now, he can apply for one if he doesn't have one through the IRS by submitting a W-7 form. Without this tax ID number, he has no way of selling the property, having the withholding done, and sent to the IRS. Because if the withholding is done and they send it to the IRS without a tax ID number, where is the money going to go? It will not go into his tax ID number. Now, let's say that the seller says, I actually lost money and I don't think that I owe the IRS any taxes. Well, even if you lost money, you still need to withhold the 10% and have it sent to the IRS. You can claim it back when you get your income taxes done, but you still have to withhold it. And that means that if you do not have enough proceeds to meet that 10% requirement, then you need to bring money in. And no, the 10% is not on net proceeds, it's actually on your sales price. Now, there is a way that you can bypass that to a certain extent. If you were to submit early in the transaction a form called the 8288B, a request for reduced withholding to the IRS, they may grant your wish to have less than 10% withheld. Now, it takes about, say, 2 to 3 months to get this withholding certificate down. So my suggestion is, if you are a seller who is a foreigner, have your CPA submit this form early and get a determination before the escrow is closed. Another way to bypass this 10% is if your sales price is less than $300,000 and your buyer is willing to sign a buyer's affidavit stating that it is under $300,000 and that the buyer is going to be living on the property as his principal residence. So there are two ways to do it, and there's another way, and that is if you are selling through a domestic stock corporation, but that is a little bit different, and as always, the seller should contact his CPA to make sure whether or not that way would apply to him. Now, when the escrow closes, the settlement agent, on behalf of the buyer, will need to send this 10% to the IRS within 20 days from the day of closing. If it is not sent out within the 20 days, there will be a penalty incurred, and the penalty by the IRS is substantial. So please, if you are a seller who is selling a piece of property, you will need to have the tax ID number, and you will need to make sure that this 10% is withheld and sent to the IRS. Is that the end of the story? No, it is not. The seller does have the right to claim this money back by submitting his income tax return at the end of the year. If this is the only property that he sold and he had nothing else that he had done in the United States, then he would file the income tax just for the sale of this property. And once that is done, you can go ahead and claim back part of the 10% that you have already sent to the IRS. Thank you very much, and I hope that this has been of interest to you. This is Juliana from Viva Escrow.